Thanks for staying on. Reporting continues now. The Democratic Alliance has filed a legal challenge against the Employment Equity Amendment Act. The case is set to be heard in the Pretoria High Court on Tuesday. The DA argues that the act introduces national race-based employment targets, which it describes as racial exclusion under a new name. The Department of Employment and Labour has published 5-year employment equity targets for 18 economic sectors in line with the amended legislation. I'm joined now by JJ van Walt, Counsel in the employment law practice at Cliffe Dekker Hofmeyr. JJ, good to have you, and thank you very much for your time. It seems the big issue, maybe there are others, is really around the determination of sectoral numerical targets in this new employment equity framework. What is the challenge there?
Thank you. The challenge primarily is to adapt in this current climate, number one, but number two, the uncertainty related to the regulations and how employers are required to implement new employment equity plans. Now, the primary challenge is, one, we have now these new regulations. Two, there are no obligation on an employer to develop new employment equity plans. In line with what you've said, there are now 18 new national economic sectors, and each of those sectors would have what we call 5-year sectoral numerical targets set by the minister. Now, previously, employers were entitled to, or had the power and obligation to set their own targets. However, that power is taken away from employers and now given to the minister. And the minister has now set these targets, which you must, as a designated employer, now incorporate into new employment equity plans. And to ensure compliance with those targets needs to be achieved within the next 5 years, which would be then 2023. Yeah, that's the...
There must be a reason why those powers would have now been taken away from the employer. One reason would have been that the compliance was low, but two was that the targets in terms of equity were taking long to reach.
Yes. 100% correct. One of the purposes of the new regulations in aim with the amended act is to not necessarily change the way we transform, but the pace of transformation. You will find that the new targets are set to target the 4 upper echelons of our occupational levels. In other words, it wants to hasten the process of transformation in the private sphere, in the 4 upper echelons of our occupational spheres, and it's aimed to target our bigger employers, as the definition of a designated employer has now changed to only look at employers employing 50 or more employees, which means the 4 upper echelons of your larger employers are now set, or the intention is to hasten the process of transformation for those occupational levels.
Now, what is another way, if this is not the way, for ensuring the increased participation of designated groups, those being Black South Africans, including Africans, Coloureds and Indians, women and persons with disability as defined in the Employment Equity Act?
Yes, so the other way to include, as it were, people from occupational levels is we should always remember employment equity is far more than just targets and numerical targets as such, but it's also the removal of barriers to entry and the achievement of equality, which entails much more than only targets. What these regulations are aimed is to set a base, to set a framework within which employers must tackle the issue that we still have in the post-apartheid South Africa, which is we need to substantively and deeply transform our society. And one of those sections of society that requires such deep transformation remains our employment sphere, and specifically our more senior employees. So what the regulations is aiming to achieve is give a platform for what we can call more deeper transformation, which is step one. Let's include others previously excluded. And then number two, it's up to our employers that once we have included those employees to transform the workplace in a much deeper way and to bring South Africans together at a very important place, which is our workplaces.
But at a very basic level, I mean, one would have to ask the question, JJ, what would be a justifiable reason? Because previously employers would set their own targets, but they failed to reach their own targets. So what was the reason for them failing to comply with the targets that they set themselves?
So one of the biggest challenges we have is how life changes dramatically with certain events. And a very good example would be when you have big transactions of where you transfer businesses from one employer to another employer. Those are recognized as a justifiable reason for not complying with the targets you self-set. And other circumstances are natural attrition and economic circumstances surrounding your business. But what is very challenging for employers is when they undertake restructuring exercises or the sale of part of their businesses. Usually that then has a dramatic impact on the workforce profile, and it's very difficult to take into account those dramatic changes in the workforce profile when you first prepare your plan.
And up until now, with all those challenges and justifiable reasons, as you put it, the employer would have been willing to pay the fine and continue with the status quo as is, as long as they've paid the fine. Now, this, of course, is part of the reason why those employment equity targets were never reached, that people in these big companies were willing to pay the fine, take the hit. It's nothing on their bottom line, but the process of transformation then doesn't carry on.
Yes, so that's correct. Is what the Act now also tries to achieve is seeking to introduce what they call a certificate of compliance. So where an employer seeks to do business with the state, what they say the enforcement paradigm is trying to do is moving away from only fines, but also to say that if you want to do work with the state, you will have to obtain what we call a compliance certificate. And what that certificate would enable you to do is to meaningfully participate into tender processes. In other words, if you're not compliant, if you didn't implement your employment equity plan, you will not have the certificate. Doesn't mean you cannot participate in the tender process, but you cannot meaningfully participate because your non-compliance will be taken into account. In that sense, what the regulations and the Amendment Act is trying to achieve is to not only threaten a company with, like you said, a fine that they are willing to pay, but they're trying to then affect their bottom line in a meaningful way, which is you cannot do business with the state.
So those who are opposing this, I mean, ultimately, what are they calling for? They're calling for the so-called targets to just be made guidelines and not be made binding quotas, which are enforceable under the law.
Yeah, so there are various degrees and ways in which the targets are being challenged. The challenges currently are very technical and constitutional in nature, but there are two various schools of thought. One which would see transformation as already been finished and finalized, what they would call a sunset clause in our transformation process. Another school of thoughts that would dictate that transformation is much deeper process. It's a process that will take much longer. And the challenges aimed at the Employment Equity Act are more aligned to the school of thought saying that we have had our time of transformation. That time has now come and passed, and therefore we should challenge these the targets, for want of a better word, as they would have had been a sunset clause. Now, that is unfortunate in that school of thought does not contemplate the idea that transformation is a long process and also a process that requires deep transformation and more than only the numerical targets that are set. But we should also take into account the fact that had transformation reached its goals that we set out to achieve within the first plus minus 30 years, the state would not have had to step in to hasten the transformation process. And one last point, that the law does not contemplate an ending process of transformation. In other words, when you have reached those numerical targets, not quotas, targets, then an employer is no longer required to just move towards the achievement of those targets. So in other words, the challenges, unfortunately, should possibly contemplate that transformation is a much more nuanced process that we've undertaken and one that has not yet been achieved.
Now, according to the timelines that would have been set, it means that from the 15th of April, compliance would have become mandatory, that the companies whose employers are 50 and more would have needed then to comply with this. What does the challenge in court that has been brought by the DA now mean for employers who need to comply with this regulation?
Simply put, nothing as of yet. The challenge is ongoing until such time as if the challenge is successful, then we would have to wait and to see and determine the manner in which the judge presiding over the matter has decided to deal with it.
Yeah.
If the sections are declared unconstitutional, one would in any event have to wait for a confirmation by the Constitutional Court. In other words, that challenge is long. It will take a long time for us to fully comprehend if they're successful, what the impact might be.
So as we sit now, as of the 1st of April, those employers who became designated are now expected, in other words, to draft a plan covering at least the remainder of the 5 years of the time frame.
Correct. That plan needs to be formulated now, and it should be then adopted before September, as from September this year. It would have to then be implemented from September 2025 until August 2030.
JJ, we appreciate your time. Thanks so much for coming on. That is JJ van der Walt, the Counsel in Employment Law Practice at Cliffe Dekker Hofmeyr, on this new employment equity legislation that came into effect on the 1st of April and its implications on the employer.